Good evening, everyone. I hope I'm audible to everybody. Okay. A very warm welcome to all of you. I am Shifa Sheikh and I will be your host for today's session. Thank you for taking out your time to join us today on this webinar on GST litigation and interpretation of fiscal statutes. This is a very practical and important area of law, especially if you are interested in litigation, taxation, or corporate practice. This session is organized by Law Jurist, a certified legal education platform that focuses on practical learning beyond textbooks. We also have DraftMate AI, that is a AI based tool designed to assist in legal drafting, research, and understanding complex topics. Just to give you an idea of today's topic, GST has transformed the taxation system in India, but it has also led to many disputes and legal challenges. Understanding how the courts interpret these laws and handle litigation is very extremely important for any law student or aspiring lawyer. Now, our honorable speaker, Mr. Umang Agarwal, is a legal counsel at Tata Steel Limited, one of the India's biggest companies, where he handles GST dispute and indirect taxation matters every day. He is not going to teach us anything from a textbook. He is experiencing it and living it. And that is exactly why today's session is going to be so valuable for everyone present here. And before we start the session, please feel free to drop your questions in the chat box. A quick Q&A session will be conducted at the end, and kindly fill the attendance form. Thank you. Now, without any further delay, sir, the screen is yours.
Thank you, Shifa. I hope I'm audible.
Yes, sir, you're audible.
Perfect. Thank you. So, thank you, Shifa. Thank you for introducing me. As you all know, that I'm currently practicing GST litigation in Tata Steel Limited. First of all, allow me to thank the entire team of Law Jurist and Ayush for organizing this seminar and having me in this to share my practical knowledge on GST litigation and interpretation of fiscal statutes. So now I'll quickly start. First, I'll display my screen. Let me know if my screen is visible. So, hope my screen is visible.
Yes, sir, it's visible.
Okay. So I could not see any questions, or even I'm not able to see the window. I'll request the Law Jurist team. So let me know if there is any issue with the audio or my screen presentation, or if there is any question in the chat box.
Sure, sir. We'll have a Q&A session at the end of this webinar.
Perfect.
Yeah.
So let us start. So this will be a 1 hour session, and I'll try to take around 40-45 minutes to discuss the topic that we have for today, and the remaining 15 to 20 minutes we can keep for Q&A, question and answers. So now, as you can see, that today's topic is GST litigation and interpretation of fiscal statutes. Now this is two topics per se. First is GST litigation, and then is the interpretation of fiscal statutes. So first we'll just try to see what is GST litigation, how it works, and then we'll quickly move on to the interpretation part. So now, coming to GST litigation, it is important to note what are the different legal framework under which GST litigation operates. The first and foremost is the Constitution. Now, Constitution via 101 Amendment Act. This is an important provision because prior to GST, we know that there were different indirect tax legislation which got repealed and consolidated in one framework, that is GST framework. So this happened via 101 Amendment Act of the Constitution, which introduced four key provisions. First is Article 246A, 269A, 279A, and Article 366(12)A. Now, what does this four different articles talks? Also, there are many other provisions that were added, but for our discussion today, or to understand the GST framework, these are the four key relevant provisions from the constitutions that is important to note. The first is Article 246A. Now, the 246A empowers both Parliament and state legislature to levy GST. So this is the most important provision which gives the power to both Parliament and state legislature. Skipping 265 comes 269A. 269A talks about levy of IGST on interstate supplies. Now, what is IGST? We'll see when we'll see the specific act. We'll discuss that. But the key thing to note here is Article 269A, which gives the power to levy IGST. What is IGST? We'll discuss. Next is Article 279A. 279A constitutes GST Council and its recommendation. You may have heard about GST Council if you are even a little bit into GST litigation, or even GST, you know something about GST, so you must have heard about GST Council. So GST Council is a constitutional body which is established under Article 279A. The most important function of the GST Council is to overview the implementation of GST and recommends changes, modification, amendments as and when required. So any amendments coming in GST Act comes to GST Council, which is established under Article 279A. Last but not least, even I'll say the most important article of the Constitution itself is Article 366. Now, 366 is a definition clause of the Constitution. Now, most of us see the definition clause in any statute is given in the very beginning, be it section 2 or section 3, but we overlook that even the Constitution has a definition clause, and it is given in the very end, Article 366. Now, Article 366 clause 12A defines what is goods and services tax. So these are the four important provisions of the Constitution when we talk about GST litigation. Now, I skipped Article 265. Now, 265 is something which were there already prior to 101 amendment. Now, this is one of the most important provision when we talk about GST litigation, or even any tax litigation. When we talk about Article 265 is what Article 32 is when we talk about writ petition. Why? Because 265 says that no tax can be levied or collected.
Hello.
Yes.
Sorry to interrupt you, sir, but your screen is not visible.
Not visible?
Yes, sir. The slide is not moving at all.
Just give me a second. Thanks for pointing out.
Yes. Okay.
I'll try to reshare. Now I've tried to reshare the entire screen. Let me know if it is. I'm
Yes,
on
now it's visible.
second slide, overview of GST litigation. It is visible.
Yes, sir, it's visible.
So sorry if it is not visible. Please look at the constitutional provisions part. That is where I am currently. You can take a snap or screenshot if you want to. So I discussed 4 articles: 246A, 269A, 279A, and 366 12A. These are the 4 articles that I have already discussed. Now I was discussing Article 265. As I was saying, that this is one of the most important article when it comes to GST or any tax litigation, as it mentions that no tax shall be levied or collected except by authority of law, which essentially means that if there is any dispute with regards to taxability of any event, one directly invokes the constitutional provision of Article 265. And if you're talking about tax litigation, the most common tax litigation is about taxability of an event. So in that sense, Article 265 is one of the most important articles. Now, that was constitutional provisions with respect to GST framework. Now let us come to the statutes that are there. So essentially we have 4 different statutes governing GST. The first is Central Goods and Service Tax Act, State Goods and Service Tax Act, Integrated Goods and Service Tax Act, and Goods and Service Tax Compensation to States Act. Now CGST, what basically Central Goods and Service Tax, CGST and SGST, State Goods and Service Tax Act, both deals with intra-state supply. Now this is important to note. What intra-state supply essentially means is supply within the state. Now, you may have gone to a restaurant, you may have purchased certain goods, you may have seen that there are 2 components of GST. One is CGST, one is SGST. In that event, please understand that the supply is taking place within the state. For example, if you are going and purchasing any electronics in a particular state, the electronic has been sold to you in that particular state. It's an intrastate supply, hence both the center and the state government has the power to charge tax upon it. That is, we call it CGST and SGST. Coming to Intra-State Goods or Service Tax Act. Now relate this with Article 269A. IGST means tax charged on interstate supplies of goods. Interstate supplies of goods meaning thereby if the goods is supplied outside the state. So if someone in, say for example, Jharkhand supplying good to, say for example, Maharashtra, that becomes an interstate supply, and the government or the authority who can charge tax is center. Only the center can charge tax on that, which is there in Article 269A. And in that case, if the center charges tax, it has to apportion 50% of the tax, 50% of that tax to the state government. So basically, what we see is in interstate supply, both state and central can charge tax. But if you see in your invoice or if any purchases that you make, if you see that IGST has been charged, you can easily now understand that that is an interstate supply, meaning thereby this supply has been taking place in another state. In that case, it is the central government who charges tax and the entire tax, and then apportion 50% of that tax to the state government. Primary example for this is online purchasing. If you are doing any online purchasing, say for example the store is set up in Delhi, and if you are purchasing it from Odisha, that becomes an interstate supply, and there you will not find CGST or SGST, there you will find IGST charged. Coming to last but not the least, Goods and Service Compensation to States Act. This is basically, we call it CES. CES is Compensation to State Act. Now, once the GST was implemented, certain states were losing revenue. Not certain, but entirely the state per se was losing out on certain revenue. To compensate states, this special act was enacted, which now has been repealed because it has a specific purpose. It has a specific period for which it can be implemented, just to compensate the state for the loss of revenue, which has been done. Now this has been repealed. So these are the basic provisions which governs the GST framework in its entirety. Having said that, let us move to the next part of the slide. Now, what is this? Let us understand GST disputes life cycle. Now, I understand that this being a GST litigation, the topic today is GST litigation. So now let us understand how the litigation works in GST. Now, the entire core of a litigation starts with an audit or an investigation. Now, one thing that I request all the audience to do is, you can have CGST Act open with you, so that it will be better, that you will comprehend better what I'm explaining. One thing I forgot to mention in the previous slide is that CGST and SGST are in perimeteria with each other. Basically, both the provisions, both the acts are entirely same. It is just that under CGST, state charges the tax, and under SGST, the state government, in CGST, the center charges the tax, and in SGST, the state government charges the tax, but the laws are similar. So now, for better understanding, I'll request everyone to open CGST Act, so that would be better for you. Coming to the very first part of GST litigation, GST dispute, is an audit or an investigation. So there are two provisions for it, Section 61 and Section 65, under which the department, the GST department, conducts an audit or an investigation, or what we called is an scrutiny of different returns that you file or any company files. Basis this audit or scrutiny or investigation, a show cause notice is issued. A show cause notice can be issued under Section 73 or 74, and currently we also have Section 74A. Now, what Section 73 or 74 basically deals with is, Section 73 empowers the GST department to issue a show cause notice for any tax that you have not paid, short paid, or any refunds that has been given to you in excess, or any ITC that you have availed in excess. In that case, a show cause notice under Section 73 can be issued. But suppose that non-payment of tax is accompanied by an intention of evading tax, basically a mala fide intention is there for fraud, suppression, or misstatement with the intention to evade tax, Then a show cause notice is issued under section 74. So the only difference between 73 and 74 is an intention part, where it is a mistake. A notice will be issued under 73, where it is intentionally, a notice will be issued under 74. Under 73, you will be proposed to pay 10% of the penalty, and under section 74, it is 100% of the penalty. So this is the second part, the second step of show cause notice. Then an adjudication order is passed once you file reply to the show cause notice. The officer issuing you the show cause notice will pass an adjudicating order under section 73 or 74 itself. Now what is important to note here is GST authority, while passing an order, act as an quasi-judicial body. Hence, principles of natural justice is applicable, where we see section 75. Now section 75 is important because it talks about, just a second. It talks about the department giving opportunity of hearing, that is audi ultram partem, and pass an speaking order. So this is a principles of natural justice which is embedded in section 75. Once an adjudicating order is passed, then you move on to appeal. First appeal, that is before appellate authority, that is basically commissioner appeals. Again, the GST department, you move and prefer appeal. Against that appeal, you have GST-AT, GST Appellate Tribunal, which has been recently established. Then you move on to GST Appellate Tribunal. Against GST Appellate Tribunal, you move on to High Court. Now, the important point to note here is you can only move to High Court if you can show that there is substantial question of law involved, which we all know being a lawyer or a law student. Then from High Court, you can move on to the Supreme Court. This is one general hierarchy in which the GST dispute works. Now you'll see that there is a different route also, which directly goes to High Court in invoking root jurisdiction. So now again, against the show cause notice or adjudicating order or the first appellate order, you can directly move to the High Court invoking the writ jurisdiction. Okay, because writ jurisdiction under Article 226 is wide, with a condition that you can establish that there is no alternate efficacious remedy. So I hope this is clear. Okay, so obviously there is a given procedure in the GST Act which gives you the procedure from audit observation till Supreme Court, but constitutional remedies are also available, that is Article 32 and Article 226, that cannot be invoked, but there are certain conditions which we call as self-imposed rule, which is alternate remedy. So this is about GST litigation. Broadly, what is GST litigation and how GST litigation works. Now, before moving on to the interpretation part of it, let me know if you have any question on GST litigation. You can put your question in the chat box. I'll just take a minute or a couple of minutes to wait for your questions on litigation part, and then we'll move on to the interpretation part. Do we have any question?
Yes, sir. We're having one question. Whether GST litigation reflects a shift from tax compliance to tax criminalization?
Tax compliance to tax criminalization.
Yes, sir.
So what I understand the question is whether GST litigation looks at a shift from tax compliance to tax criminalization. No, not. Because if you are not compliant, if you are not a compliant company, anyway the authority will come to you. Okay. Now the criminalization part comes under section 73 and 74. What we saw. 73, since there is no intention involved, okay, it's not criminal in nature. 74, as we mentioned, that it is intentional. If the authority can show that there is any non-compliance, what do we understand by non-compliance? In GST, the non-compliance effectively what it would mean is non-payment of GST. That is it. If suppose there is a procedural non-compliance, suppose you have filed your return wrongly, but there is no revenue loss or there is no tax that has not been paid to the government, then there cannot be a criminalization aspect attached to it. But if you are not paid tax, you have not complied, there is no compliance, and you have not paid tax, you have availed excess tax, and if the authority can prove that this is intentional, then 74 notice follows. Whether 74 is criminal in nature? Again, no. Though I am saying it is intentional, but 74 is not criminal in nature. So far as you are able to, so far as you pay 100% of the penalty of the tax amount that you have not paid. So if you make the payment of 100%, it is not criminal. Coming to other provisions, yes, there are criminal aspect involved. For example, if a recovery notice, which is section 79, if a recovery notice is initiated against you and you abscond, you become absconding. If there are certain taxes that you have not paid and you are absconding, then a normal criminal proceedings can be initiated against you. So I to answer that question, no, GST compliance has not turned into tax criminalization, because per se, if you are willing to pay 100% of the penalty, there is no criminal action that will be initiated against you. Hopes that answer the question.
Thank you, sir. We have another question. Can we move straight away from show cause notice to High Court, Supreme Court via writ jurisdiction? How and on what basis?
How and on what basis? How? Via Article 226, you can approach a High Court. 226 gives wide power. That is, you can approach High Court for violation of your fundamental rights or for any other legal rights. So this is the wording of the 226, fundamental or legal rights. So yes, department being a government entity, state, you can directly move on against the show cause notice to High Court. But please note, this is very important if you are into litigation, that you have to prove that there is no alternate remedy available to you. Now let us understand this from an example. Suppose a show cause notice has been issued to you. What is the option that is available to you? You can file the reply to the show cause notice and the matter will be adjudicated. So that is an alternative remedy available to you. Now the court will ask you, why have you come to me directly, High Court, have not filed a reply to the show cause notice? Why have you come to me directly? Now this is the question which means alternative remedy question. Is where we have to show that filing reply against the show cause notice was not efficacious and will not result in any remedy to you. Once you're able to prove that there is no alternative remedy, then you can approach the High Court, that is under writ jurisdiction. I hope that answers your question. So the answer basically depends upon the alternative remedy.
Thank you so much, sir. Also, another fellow is asking, should a law student start direct tax litigation first and then go to GST, or can directly start GST practice?
So this is the question which is outside the today's discussion. This is with respect to career, choosing a career. But just to answer what interests you, this can be the answer what interests you. Both are two different litigation. Direct tax is slightly different from indirect tax, and this totally depends upon your interest. So yeah. Do we have any other question?
Thank you, sir. No, not for now.
Okay. So this is with respect to GST litigation. Hope you have understand broadly how the GST litigation works. This is a very important slide if you are interested into GST litigation, or if you want to study GST. Now let us come to the interpretation part of it. Now this is very interesting and important when we understand interpretation. So today's discussion is more connected with the interpretation of a fiscal statute. Now before moving on to that part, let us briefly see what are the few principles of interpretation that you may have already studied. So first we have literal or grammatical rule, which, as the name says, the court goes by the very literal meaning of a statute, literal meaning of the words, which is literal rule of interpretation. The second is purposive interpretation, or the mischief rule. Now this is important with respect with respect to any statutes which try to remedy a mischief. Now, just to understand through an example, a very famous case law that we have is of Smith versus Hugh. Now, what happened in that case? Now, there was an act, a Street Offences Act 1959. Now, what does this act prohibit was that you cannot solicit in a street or public place. So this is what it criminalizes: soliciting in a street or public place. Now there was a person who was soliciting from a balcony. Now can the question arise whether a balcony can be considered to be a street or public place? Now the court went upon to identify what is the mischief that the act is trying to remedy. The mischief that the act is trying to remedy was stopping public solicitation. Now, this public solicitation would include soliciting from a balcony. Hence, the court interpreted that balcony would come within the meaning of street or public. This is what purposive interpretation or mischief rule of interpretation means, that the court goes on to the root of a statute to identify what is that mischief that the rule is trying to remedy or the law is trying to remedy. Third and the most important, and we all know, is golden rule of interpretation. Basically, golden rule of interpretation gives the court wide power to include or to modify even a meaning of a given word. The prime example that we have, that we can think of, is Article 124, if I'm not wrong, of the Constitution, which talks about appointment of High Court and Supreme Court judges, wherein the word used is consultation, but the court interpreted to mean concurrence. And this is a very famous debate, that is the independence of judiciary, which will go on, which on some other day, that if we have time. But golden rule simply means that the court can look into the context, the court can look into the historical data, be it parliamentary debate, be it any other documents. The court can look into the intent of the legislation and give the meaning which suits best as per the court. This is what the golden rule of interpretation means. Now, the fourth and the most important rule, which is there for our discussion today, is the strict rule of interpretation. Now, what a strict rule of interpretation means: basically, literal rule and strict rule are kind of same. If just to explain that, literal rule can be a bigger circle and strict rule can be a subset of that. Strict rule simply means the court will strictly go by the black letters of law, and this is the rule of interpretation that is applicable in the fiscal statutes, most importantly in any taxing statute. Now let us come to this slide. This is one of the most important slides for today's discussion. Taxation statutes, principle of interpretation. Rather, it should be principle of strict interpretation. As I mentioned, that in taxing statute, the court follow the principle of strict interpretation. What does this mean? Number one, it involves literal or plain meaning test. There will be no addition, modification can be done if the court finds that by giving a literal interpretation, it serves the purpose. That is the first rule of strict interpretation. Second is, any other tool of interpretation, be it contextual, purposive interpretation, headers, parliamentary debates, legislative debates, will not be applied, nor the court can make any resort to such tool for supporting the interpretation. It will only goes by the black letter of law. Now, third and the most important thing is that equity has no place in interpretation of tax statutes. Now, if you see other laws, for example, criminal law or civil law or any other public policy, the court generally tends toward the principle of equity. If you have been in any courts, or even if you have been in any moot courts, you'll see that in the prayer, the last prayer is any order that deems fit in the principle of equity and good conscience. So the principle of equity in tax is not available. It is again repeating black letters of law. Fourth, nothing can be read into or no nothing can be implied other than what is essential while considering the text statutes. There cannot be any inference, assumption, presumption by the court. Fifth, no hardship. Now this is an important part, and we'll see in the next slide what does this mean. That a court will not consider any hardship in or any impossibility or hardship of a particular provision while interpreting the text statute. I'll park this topic. We'll see in the next slide. Now again, one of the important point of strict interpretation and interpreting the taxing statute is that even applying all the above principle, there are two possible interpretation of a text statute is possible. The court will prefer the interpretation which is in favor of the assessee. Now the prime example of this can be one of the actual cases. What happened where rice bran oil was in dispute whether it can be taxed or not. What was mentioned in the statute was animal feed substance will be taxable. Whether rice bran oil forms part of animal feed substance was not there. Neither does the word animal feed substance was defined in the act. The court simply mentioned that since the legislature itself did not define the act of animal feed substance, and by referring to a legal dictionary, Black Law dictionary, we can understand that rice bran oil does not form part of animal feed substance. Then in that case, it cannot be taxed. So if in applying all the above principles, even in that case, two possible interpretations are possible. It will always be interpreted in favor of assessee. Now this is what strict rule of interpretation means. Now let us see. I hope everyone have GST Act open or with you. You can open it in your laptop, or if you have a book, you can open in a book. Now this is very interesting. As in the very beginning, the team mentioned that what we will understand is not only theoretical part of the interpretation, but we'll see it in practicality. What happens in practical scenario. Now before you is an actual provision of the CGST Act, section 16, clause 2, subclause C. I'll just pause for 10-20 seconds for you to open this provision if you have your Bare Act open with you. Just open this. And please just mention in the chat quickly if you have any idea about what is input tax credit, ITC, input tax credit. While you're opening section 16(2)(c), please just mention briefly yes in yes or no, whether do you have any idea of input tax credit, ITC. If someone can read the chat, that's yes or no. Are you able to hear me?
Yes, sir.
Is there? Do we have any response?
We have two. One is yes and one is no.
Okay, so I'll just briefly introduce what is input tax credit. It simply means that the credit of the tax that you have paid while purchasing an input. Now, section 16(2)(c) lays down a condition for availing such credit. Condition is just we can ignore the deleted part and the part in the bracket. Subject to the provisions, okay, the tax charged in respect of such supply has been actually paid to the government either in cash or through utilization of input tax credit admissible in respect of the said supply. Now this is an actual provision which is debated, highly debated, currently is in dispute in GST legislation, which is pending adjudication. It has been adjudicated by few high courts, but it is pending adjudication from Supreme Court. Now what does this provision says is that if you have purchased any input for a business, if you are a bona fide recipient of an input, you will not be entitled to claim ITC, input tax credit, of that purchase if the supplier has not paid tax. If your supplier has not paid tax to the government on that supply, you will not be entitled to the ITC. Now, this creates a huge anomaly. Anomaly in respect to, if suppose I am a bona fide purchaser, I am running a business and I have purchased, say for example, a notebook for my business. I have paid certain GST on that. I have paid it to the supplier, but the supplier has not paid it to the government, and the government is restricting my ITC. Do you think? And now I went on to I go to the court and I say to the court that look, I have paid my taxes. I am not the one who has defaulted here. You cannot deny me the credit of the tax that I have paid. Now, do you think that the court will hear me? The court will grant me the relief. Take a time, take a minute or two. Try to answer this question. Now consider that I am a bona fide purchaser. I have paid my tax to the supplier. I am using the supply for my business purpose, but it is the supplier who has not paid the tax to the government. The government will deny me, saying, look, there is a provision, section 16, subclause 2, subclause C, which entitle you to avail ITC only when your supplier has paid tax. Hence, I will not allow you the credit. In that case, what do you think the court should do? Whether the court should allow me the credit of the tax that I have paid? So the answer is, going by the strict interpretation, no, the court will not allow, and that is what almost every high court have done. There have been like 7 or 8 high courts who has delivered the judgment on this very question of law that we are discussing right now, and the court has said no. If there is a provision which is clear that you will not be allowed ITC if your supplier has not paid tax, we will not allow. Although, having said that, although the court has read down this provision, read down in the sense that the court has said, if you are a bona fide purchaser, there are 2 ways that the court has read it down. If you are a bona fide purchaser and you have proved that you have made payment of tax to the supplier, you are using your goods for your business purpose, and in that case, if the authority has initiated any action against the supplier, in that case you can avail the ITC. Now, what my purpose of bringing this provision to you is that there are 2 things when we talk about interpretation. One is interpreting it in a sense that to assign meaning to certain words. Here, the court has decided not to do that. The court has decided not to assign any meaning to the entire provision of section 16(2)(c), which is quoted in the screen. Why? Going by the rule of strict interpretation. The second part of the interpretation means is reading down the provision. Reading down the provision means the court will interpret in such a way that the word remains same, the meaning remains same, but the application is reduced, or the application of this provision is to the extent that this is not in disharmony with any other provisions. So the court has read down the provision of section 16(2)(c) to say that if you are a bona fide supplier, if you are a bona fide recipient, you have made the payment of tax, and the supplier has absolutely absconded. No tax can be recovered from that supplier. Only in that circumstances your tax can be, or your credit of your input tax can be disputed. I hope this is clear. I hope what is strict interpretation is clear. And I hope when I mentioned that there is no principle of equity in strict interpretation, there is no principle of hardship in strict interpretation. Now, this is a prime example of hardship. One may say that I am a bona fide recipient, I have paid my tax once. You cannot ask me to make me to pay my tax twice. That's a hardship upon me. But this is not applicable when we talk about and interpreting taxing statute, which is interpreted under the principle of strict liability. I hope this is clear. This gives you a practical perspective of how this interpretation works. Now let us move on to the next topic, that is different parts of a taxing statute. Now, when we talk about strict interpretation, does this strict interpretation is applicable to the entire CGST Act that we are talking about, entire IGST Act or entire SGST Act that we are talking about, or certain parts of that act? So the answer is certain parts of those act. One is charging section, enabling section, then penal section and procedural part. And obviously we have other provisions as well. Now what is charging section in tax law? Excuse me. Charging section means the section which empowers the government to charge tax upon a particular incidence. For example, in income tax, the point of taxation or the incidence of taxation is income. The moment you have earned any income, it becomes taxable under income tax. Similarly, under GST Act, as per the charging section, the incidence of tax is supply. So section 7 of the GST Act talks about charging section, which empowers the government to charge tax, namely GST, CGST or SGST, on supply of goods. Now the strict interpretation principle, always remember, the strict interpretation principle is always applicable only upon charging section or enabling section. You cannot apply the strict interpretation part to the procedural part of the act. For example, now we studied about section 73, we studied about section 74, section 75. Now section 73 talks about, or rather say section 107, which talks about the first appellate order. In the previous slide we mentioned that. Now under section 107, it is prescribed that one should file appeal within the period of 3 months, which is condonable, or 3 months, and with an extra 1 month condonable period. Suppose 3 months has been elapsed and further 1 month has also been elapsed. Can you file appeal? Now the question will lie before the High Court or the Supreme Court. The court may allow, may not allow. It is purely upon the decision. We will not allow the appeal which are filed even after the period of month. They are easily, that means procedure part of that means also on penal sections. So this is where the strict interpretation lies in a taxing statute. Most importantly, charging section and enabling section. Enabling sections are the sections which enables the charging section per se. For example, if section 7 talks about charge of tax, then the valuation of goods, time of supply, these are all enabling sections which enables the government to charge, implement the charging section itself. These are the different, we have to understand the different parts of a particular statute. I hope this is clear. Now let us move on to the next part. Now this is an important slide to understand. Now we discussed that there are different frameworks in GST. One constitution above and over every other law. Then we have CGST, SGST, IGST. Okay. Apart from this act, there are a number of circulars, there are a number of notifications, instructions that are issued by the Revenue Department. In GST, the Revenue Department which we are talking about is CBIC, Central Board of Indirect Taxes and Custom. Now, it issued number of circulars, number of notifications for the implementation of the act itself. Now, how can these subordinate legislation can be interpreted? What are the rules of interpreting this subordinate legislation? Now, first, there is a difference between a notification and a circular. A notification is an extended part of an act itself, or one may say the notification provides the enactment of certain of the law. Hence, the notification is always given a strict interpretation because it is an extended part of the act itself. Then we have exemption notifications. Now, exemptions notifications are different from notifications. Exemption notification sets out an exemption of certain parts on which tax is paid. Now, remember that exemption notifications are always interpreted. If there are if two possible interpretations are available, the exemption notification will be interpreted against the SSE. It will not go in favor of the SSE because it is understood that an exempt to claim certain exemption, the exemption notification should explicitly mention that if suppose agricultural product is exempted from GST. Suppose we take an hypothetical example. To claim that your product become part of an agricultural product, agricultural good, it should be clearly coming out from that exemption notification. Otherwise, it will be interpreted against you because you are going to take the benefit of certain exemption notification. So that is the rule of interpreting exemption notification under GST. Then comes the circulars. What are circulars? Circulars are basically clarificatory in nature, or circulars basically are instructions that the department issues. First and foremost, are circular binding? No, circulars, one may argue that circulars are not binding on the taxpayer. If the department issues certain circular, it is not binding upon the taxpayer. It is binding upon the revenue. Yes, it is binding upon the revenue because it is their own circular. Hence, if there is any question of interpretation of a circular, it will be interpreted against the revenue. So this is the rule of interpretation. Now there is just one more very interesting food for thought and very interesting concept in GST that has not been mentioned in this PPT that I like to highlight is section 155. This is very interesting section. If you have the book open with you, Boyer Act open with you can go and refer to this section 155, which talks about reverse burden. Now, unlike if reverse burden of proof. Now, if you have studied Evidence Act, you would know what is burden of proof. So, burden of proof is simply one who asserts a fact needs to prove it. That is applicable in the general statute. One who asserts certain fact, one who says certain fact needs to prove that fact. However, when we come to GST, there has been a specific provision which reverses that burden upon the assessee. Now, if the department comes up and say that you have availed excess ITC, you have availed ITC credit more than what you should avail, now the entire burden shifts upon the assessee to prove that the ITC has not been availed in excess, or the ITC that has been availed is in accordance with law. That is the reverse burden that is there in the GST. Now, just a food for thought, one may go and research to what extent this burden can be implemented, or to what extent the assessee can be asked to prove. For example, if a company like Tata Steel may avail ITC to the extent of say 10,000 crores, is company required to prove each and every ITC that we have that is the company is availing? Yes or no? That is something which is open to discussion. Now, these are the few landmark judgments. You may take a note of this. You may take a screenshot of this if you want to read upon more how the interpretation of a fiscal statute work. The first is the most recent judgment of the Supreme Court. Dilip Kumar, go read the judgment. The entire fiscal statute interpretation would be clear to you. You may take a screenshot. I believe I have to remove this. I think now it should be visible. Yes. Yes. So yeah, that is all from my part. I hope you found this session interesting. You have learned something new, and if there are any questions, we have 10 minutes to us. Please shoot your questions.
Okay, sir. Thank you so much for the session. And can I start asking the questions now?
Yes, please.
Okay. So, a fellow participant is asking, how should one strategically approach petitions in GST matters, especially in cases involving ITC blockade or refund disputes?
Now, this is a very good question. Now, this is a question that almost every litigant suffers from. Now, as I mentioned clearly, so what the approach the High Court takes is, if suppose ITC blockade case, if you can file the reply and get the matter adjudicated, if you can file the appeal, if you can file appeal before GSTAT, then why approach me? This is the approach that the High Court takes. Now there is a reason why this approach is taken by the High Court. Please go and read upon the principle of alternate remedy. This is not a principle which is mentioned anywhere in the statute. As you may see from the word principle. Principle, what does the principle means? Principle means that this is not a written law. This is not something which is written. This is a principle which is coming out from a judicial judgments. A principle of alternate remedy is a self-imposed rule, which the court says that this is the rule that you have imposed upon yourself while you are approaching a writ court. So once you can prove that there is no alternate remedy available, once you can prove, even if I go to the adjudicating authority or to the appellate authority, I will not get relief because of a genuine reason. No, don't, you cannot say that, okay, because there is that the authority is against me personally. No, that will not work. If you can show that that you cannot get relief from the authority, then you can approach the High Court saying that there is no alternate remedy for me apart from approaching this court. In that case, you can approach the writ court. There are three exceptions to that. I would highly recommend you to read a Supreme Court judgment of Whirlpool Corporation. Whirlpool Corporation. It's a very landmark judgment on alternative remedy. Hopes that answer your question.
Thank you, sir. Another participant is asking, from your experience, how is GST litigation expected to evolve in the next few years, and what opportunities does it create for the young professionals?
This is also a very interesting question. Now, talking logically, keeping things, legal things aside, talking logically. Now, GST is the law which came in the year 2016. GSTAT, the second appellate tribunal, was established last year. So there have been no substantive matters that has been adjudicated from tribunal and above level to answer the questions of law. For example, the question of section 16(2)(c), which we discussed, there have been no opportunity for the Supreme Court and High Court to adjudicate this. Similarly, there are a number of other questions. So in my understanding, since now the GSTAT has been established, the GST litigation floodgate will be opened, because everyone was waiting for a tribunal, because there was no link. If you see, you have show cause notice, your first appellate authority, the second appellate authority was not there because you are not able to move to the High Court and Supreme Court. The cases were stuck. Hence, it has not been, the moot questions of law had not been adjudicated yet. So it is upon the tribunal now. They have to adjudicate this. The more they'll adjudicate, the more question of law it will open. The more question of law it will open, the more it will go to High Court and Supreme Court, hence expanding the GST litigation. So, logically speaking, in my understanding, the GST litigation has good days ahead.
Thank you, sir. Another question, with evolving jurisprudence under GST, how can lawyers stay updated and effectively interpret the fiscal statutes in practice?
Read judgments. That is one thing that I can say. If you want to understand interpretation of statutes, read a book by G.P. Singh. It is a very famous, profound book which even the Supreme Court cites in multiple of its judgments. That is it. There is no other way. You have to be updated. You have to read judgments of the court on regular basis to understand the GST litigation, to understand the interpretation of fiscal statutes.
Okay, sir. Also, which rule is mainly used in tax law interpretation? A company claims ITC, but GST officer denies it due to mismatch in invoices. So, what is the remedy available?
Again, this if look, this is more of a factual question. If there is a mismatch, the department denies you the remedy, what will you do? You will file appeals showing that there is no mismatch. There's one thing to do that. So this is more of a factual question. If you are able to show to the authority that there is no mismatch, go on to appeal to Supreme Court. There's one thing. There's no rule of interpretation in this. You have to show that there is no mismatch. Ultimately, you cannot escape tax. If you have availed excess ITC, you have to pay that. Now, coming to the second part of it, if you feel now on the litigation part of it, if you feel that this notice has been issued wrongly, say for example, wrongly under section 74, there is no element of intention in this case, or the notice has been issued beyond the prescribed period of limitation, or the notice has been issued not by the proper officer, which and then hence is without jurisdiction, or the notice or the order has been passed without following the principles of natural justice enshrined under section 75. In all these cases, you can directly go to the writ court, or you can again fight the matter on legal grounds. But there is no rule of interpretation involved in this, because there is no dispute as such. But if you again come to section 16 to see where ITC is denied because the supplier has not paid tax, then that becomes a matter of interpretation, where we'll see how the court again, that is a food for thought for you guys also, to do research upon that, research upon the constitutional validity of section 16 to see whether it's constitutionally valid or not. And yes, that is it. Basically, in tax statute, it is strict interpretation, but in specific to your question, it is more factual.
Okay, sir. Another one of our international participants, Sam Siran, he is a very regular one though, is asking what differentiates GST litigation from other forms of litigation like income tax.
Okay, so no, there is no major difference between GST litigation or any other like tax litigation if you're talking about income tax. The only difference is with respect to substance, the factual part. The principles remain the same. For example, here you have GST 80, GST Appellate Tribunal, and income tax you have IT 80, Income Tax Appellate Tribunal. Similarly, in the legacy laws, that is Excise Act, Service Tax Act, you have CSTAT, CESAT, Central Excise Custom or Central Excise Service Tax Appellate Tribunal. Similarly, in case of central tax, earlier central tax, now repealed obviously, you have Central Tax Tribunal. So point is, the principles of strict interpretation remains the same. The point is, principle of natural justice remains the same. The point is, principle of alternative remedy remains the same. When it comes to the litigation part of it, the principles, almost all the principles remain the same. It is just the difference is on just on substance. Hope that answers your question.
Thank you so much, sir. And this is the last question for the session. In the GST litigation, how strictly should fiscal statutes be interpreted, literally or purposively?
So, as we discussed, there is no concept of purposive interpretation in fiscal statute. No court will go on to say, okay, I am going with the purposive interpretation. It has to be strict interpretation. When we are talking about charging section, as we saw, there are different parts of the statute. When we see charging section or the enabling section, it has to be a strict interpretation. But obviously, the constitutional court, be it Supreme Court or the High Court, have extraordinary power to read down a particular provision. Reading down or giving a purposive interpretation are two different things. They may read it down, but it will always be strict interpretation. No court will go on to say that, okay, I'll apply the golden rule of principle or purposive interpretation. Hope that answers the question.
Yes, sir. Thank you so much. If anybody is not having any questions, let's get to the thanks vote of thanks. So, thank you so much, sir, for such a clear and insightful session. I would also like to thank the Law Jurist team and Draftmate AI for organizing this webinar, and all the participants for joining us today. We hope you found this session useful and informative. Please don't forget to fill out the feedback form shared in the chat. And thank you so much. Have a great evening.
Thank you, everyone. Thank you.